Scrutiny of Nominations. Disclaimer. This training material is for use in training of election officials. It should not be referred as guidelines of ECI. In case of any variance in this training material, the ECI guidelines or rules or laws shall prevail. Learning objectives. At the end of the session, the participants will be able to understand that the scrutiny of nomination is a quasi-judicial function of RO. Know that at the time of nomination filing, RO is required to give to each candidate the notice regarding the date, time, and venue of scrutiny. Accordingly, the scrutiny has to commence as per the notice already given. Explain the legal provisions regarding the scrutiny of nominations. Familiarize with the prescribed forms and formats and strictly follow them. Note that while RO may informally obtain inputs from other sources, the decision of accepting or rejecting nomination lies only on the shoulders of the RO. What is scrutiny? As per Section 36 of RP Act 1951, scrutiny of nomination papers will be done by returning officer himself or herself. What are the exceptions? Only under extremely rare instances of unavoidable circumstances, RO can authorize any one of the ARO to undertake scrutiny. If it so happens, RO would record immediately the unavoidable reasons for such delegation of power. Also intimate the district election officer about it before authorizing the ARO. Date, time, and place of scrutiny. Date of scrutiny specified by the ECI will not be changed by the RO. However, RO has a discretion under the law to fix the time and place of scrutiny, as per Section 35 of RP Act 1951. The RO has to give notice about scrutiny both in public notice in Form 1 and also in the receipt which he has to give to each candidate in acknowledgement of receipt of nomination. Persons allowed in the room are candidate, his election agent, one of his proposers, one other person authorized by the candidate. Scrutiny of nominations is a quasi-judicial function of the RO, but that does not give him the status of a court. The inquiry into the question of validity or otherwise of a nomination paper is a summary inquiry. All authorized persons present at the time of scrutiny can inspect all nomination papers and attached documents. No one will physically handle the nomination papers. Presence of a candidate or his representative is not mandatory at the time of scrutiny. Even if none is present on behalf of a candidate, the nomination paper shall be scrutinized on merits and appropriate decision shall be taken. How to conduct scrutiny? The whole process of scrutiny of nominations should be covered by videography in all cases for ensuring more transparency in the scrutiny. All nomination papers should be scrutinized one by one and decision accepting or rejecting should be recorded on each nomination paper separately. Even if one of the nomination papers of a candidate is accepted, his remaining nomination papers must also be scrutinized individually. Where any objection is made against any nomination paper, RO must record his decision giving reasons for accepting or rejecting the objection. RO can raise objection to any nomination suo motu also. If the nomination of a candidate has been objective, he should be given reasonable opportunity to defend its candidature. Scrutiny can be adjourned maximum up to the second day after the day of scrutiny. Scrutiny in such case has to be completed by 11 am on that day. If the nomination of any candidate is rejected, Reasons for rejection should be recorded in brief and copy of the order should be provided to the candidate. Presumption of validity. There is a presumption that every nomination paper is valid unless the contrary is prima facie obvious or has been made out. In case of a doubt as to the validity of a nomination paper, the benefit of such doubt must go to the candidate concerned and the nomination paper should be held to be valid. Crucial date for determining qualification. The qualification or disqualification of a candidate should be related to the date fixed for scrutiny of nominations. Grounds for rejection of nomination papers. Section 36(2) RP Act 1951. Not qualified or is disqualified on the date fixed for scrutiny of nominations. Nomination paper not signed by candidate or by requisite number of proposers. Requisite security deposit has not been made. Certified extract of entry in the electoral roll not submitted if candidate is contesting election from a different constituency. If, even after notice by RO to file affidavit or fresh affidavit with all columns filled in, the same is not submitted by the candidate, requirements of Section 33 of RP Act 1951 are not fulfilled. Section 33 of RP Act 1951. Nomination form to be submitted by candidate or one of his proposer from 11 am to 3 pm on specified dates. From reserved constituencies, candidate has to be from that category subject to other conditions. If a person who was holding defined office of profit and was dismissed and period of 5 years have not been passed, then he shall submit a certificate that he has not been dismissed for corruption or disloyalty to the state. Misnomer or inaccurate description or clerical, technical or printing error in regard to the name of the candidate or his proposer in the electoral roll shall be overlooked. When a candidate is an elector from another constituency, then a copy of the electoral roll of that constituency or of the relevant part thereof or a certified copy of the relevant entries shall be submitted by the candidate. Grounds for rejection of nomination papers. Affidavit Form 26 has not been submitted. Failure to furnish affidavit or any column is left blank even after notice by RO. Candidate of general category filed nomination from reserved category. The nomination paper has not been signed by the candidate and or by the required number of his proposer. The oath or affirmation is not made by the candidate as required. Where the candidate is not an elector of the constituency, he has neither filed a copy of the electoral roll in which he is registered or of the relevant part thereof, or a certified copy of the relevant entries relating to his name in such electoral roll. If the candidate has filed nomination from more than 2 constituencies, then his nomination from the 3rd or 4th and so on constituencies will be rejected. But before rejecting the nomination forms in such case, the RO must satisfy himself beyond any doubt. Insufficient ground for rejection. Nomination paper shall not be rejected on ground of defect which is not of substantial character. Any mistake or error of a technical or clerical nature should be ignored. Failure to complete or defect in completing a declaration regarding symbols in the nomination paper, the year of election, the exact name of the Lok Sabha or Vidhan Sabha, or any minor error in the name of the constituency, the description of an electoral roll number, the choice of symbols, some discrepancy between the name, age or other particulars of the candidate or his proposer as given in the nomination paper and in the electoral roll. Any wrong information in candidate's affidavit ipso facto is not defect of substantial character. However, failure to furnish affidavit even after notice by RO is defect of substantial character entailing rejection of nomination. Form A and Form B. Nomination paper filed by a candidate claiming to have been set up by a recognized national or state party subscribed by only one elector as proposer will be rejected if notice in Form A and Form B from that party has not been delivered in due time. If a candidate has filed more than one but not more than 4 nomination papers, some as candidate of recognized political party and the other as candidate of unrecognized political party or as an independent candidate, in case the nomination paper filed as a candidate of a recognized political party is rejected on the ground of the non-receipt of the forms A and B by 3 p.m. on the last date for making nominations from the concerned recognized political party, any or all other nomination papers will be accepted if the same are proposed by 10 electors and are otherwise found valid on scrutiny. In such a case, he would be deemed to be a candidate set up by an unrecognized party. If the requirements by the nomination paper is fulfilled and such party has sent notices in Form A and B by 3 p.m. on the last date for making nominations and otherwise as an independent candidate. In such event, the choice of symbols in the nomination paper with 10 proposals first delivered to the returning officer by that candidate or on his behalf will only be considered whether that nomination paper is accepted or rejected during scrutiny. If a candidate has filed one nomination paper with both Part 1 and 2 and he fails to bring forms A and B from the concerned political party, the nomination paper may be accepted if Part 2 is properly filled and subscribed by 10 electors as proposers. Such candidate will be considered as an independent candidate. If a candidate who filed his nomination paper as candidate claiming to be set up by an unrecognized political party fails to bring forms A and B, his nomination paper will be accepted if it is subscribed by 10 electors as proposers, and he would be deemed to be an independent candidate. The nomination paper of a substitute candidate of a recognized political party signed by only one proposer will be rejected if the nomination paper of the main approved candidate of that recognized political party is accepted. However, if such substitute candidate has also filled Part 2 of the nomination paper with 10 proposers or filed another nomination paper with 10 proposers, his nomination paper will be scrutinized independently by treating the candidate as an independent candidate. Further, if the nomination paper of the main approved candidate of the party is rejected, then the substitute candidate will be treated as the candidate of the party, provided that the party has already intimated his name as its substitute candidate in Form A and B filed before 3 p.m. on the last date for making nominations. State party. A state party which is recognized in some other state or union territory but is not recognized as such in RO's state or union territory, such party should be treated as unrecognized party by returning officer even if it has been allowed by the commission to use its reserved symbol in his or her constituency. Preparation of list of validly nominated candidates. After the completion of scrutiny proceedings, RO should draw up a list of the validly nominated candidates in Form 4. Arrangement of names in Form 4 should be on the same lines as in the list of nominated candidates. List of validly nominated candidates Form 4 is shown on your screen. Recognized national and state political parties belonging to the state, registered unrecognized political parties including state parties of other states, independent candidates. Name of candidates will be arranged in alphabetical order for each category. No objection to the addition of any honorific, academic, hereditary, professional, or any other title to the name of a candidate. However, such title should on no account be taken into consideration in the arrangement of names in alphabetical order. List is to be prepared in the language specified in the Commission's direction dated 16 September 2008 for Assembly constituencies and directions dated 6 February 2009 for parliamentary elections. Category headings should not appear on the ballot papers. Follow-up steps after scrutiny. 2 copies of the list of validly nominated candidates should be sent to the Chief Electoral Officer by the next available post or by fax or email or by special messenger. 1 copy of the list along with an English translation should be forwarded to the Election Commission. The list of validly nominated candidates should be sent by RO immediately on the very day on which scrutiny of all nomination papers is completed so that it may reach the Commission before the last date for the withdrawal of candidatures. Do's during scrutiny of nominations. The RO has to be guided by his or her own judgment based on the position of law and applicable rulings without any apparent outside influence. Give reasonable opportunity and time for resolving a particular objection or deficiency. If specifically requested by a candidate or agent, time may be granted for replying to objection by adjourning scrutiny. Clarify all doubts through legal division of the Election Commission much before the start of scrutiny. Give benefit of doubt to the candidate in case of doubt. Don'ts during scrutiny of nominations. Under no circumstances should the RO be in telephonic consultation during the scrutiny. Not giving reasonable opportunity. Wrongful rejection of a nomination. Special treatment for any candidate. Risks in regard to rejection or acceptance during scrutiny. Lack of understanding of legal provisions or Commission's guidelines have created situations in the past where different ROs have taken mutual contradictory stand in similar facts and circumstances in accepting or rejecting nominations. Therefore, most imperative for each RO to read the grounds for rejection along with ECI instructions, frequently asked questions, do's and don'ts, judicial precedents. In case of any doubt or any clarification, you can contact through the mail address shown on the screen. For other election related videos, you can visit the web address as shown. Thank you.